Good morning. I'm Michael Kirby, and I was a Justice of the High Court of Australia. And I now have the honour of speaking at the plenary opening session of the Occupational Therapy Australia conference. Now, I'm as angry as ever because this was supposed to be a conference in beautiful Cairns in northern Queensland. I can still hear the beautiful waves crashing on the beaches, and I was really looking forward to that. But unfortunately, one of the smaller problems that has been presented by the coronavirus has been the cancellation of the Cairns conference, and the fact that we are doing this conference by audiovisual link. This has become a feature of our lives today, but we must be grateful that the skills of the technologists have made it possible for us to speak across our great continental country with each other and to share thoughts and to share experience and to hopefully come up with new ideas that will be of help to our country and to occupational therapists throughout Australia. I begin, as has become traditional in Australia, with a message of respect for the First Nation peoples of our country. Right across this vast land, there are Aboriginal communities and people and individuals and Torres Strait Islanders, Indigenous people all, to whom we pay respect. I was a justice, as I've said, of the High Court of Australia, and it was that court in 1992 that decided the Mabo case and upheld the claim of Indigenous First Nations people to their own traditional lands, unless some other claim of right had been established to repel the claim of the Indigenous people. And so that was not an issue which was ultimately resolved by the elected legislatures of Australia. It was an issue that was resolved by the highest court of the land. And that happened before I was a member of the High Court of Australia, but it was a decision that led on to many other decisions during my period of service. And it is part of a theme that is going to run through my remarks today about the importance in the area of occupational therapy and in the areas elsewhere in our country's story, the importance of minorities and particularly the importance of the Indigenous communities who are the First Nations people of our land. My themes in these remarks are going to be threefold. I'm going, first of all, to say something at the beginning about the importance to occupational therapists and indeed to all healthcare and other professional groups to collect the history of occupational therapy in Australia and to record that history so that it will be available for those who come along and enter occupational therapy and need to know where we've come from to reach the point that we're at in this age in respect of occupational therapy. The second theme I'm going to address is that of human rights, universal human rights, because increasingly, as we've seen in the reports of the Royal Commission into aged care and the other inquiries that are proceeding now in Australia on issues of professional groups looking after minorities, increasingly the steps that are being taken are viewed through the spectrum of universal human rights. And I want to place my remarks today firmly in that context, because that is a context that's going to be of increasing importance in the resolution of the issues of occupational therapy and also of the law and of our society more generally. And finally, I'm going to wrap up with some remarks concerning minorities, and especially two minorities that I think need attention. First, the Indigenous First Nations people that I've already mentioned, and secondly, the sexual minorities who, by reason of sexual orientation or gender identity and identity and expression have sometimes been neglected in this country. And I'm going to speak a little there from my own perspective and share with you that perspective, because it's important that people like me should do so. So let me start first with some remarks about the issues of the history of occupational therapy. It was surprising to me when I was first asked to speak at this opening plenary that there was no weighty tome or volume that set out the entirety of the history of occupational therapy in this country. Professor Anne Cusick, who is the chair of the discipline of occupational therapy at the University of Sydney, put me in touch with such writing as exists in the field of occupational therapy to explain how this came about as a discipline in Australia. And it's very interesting to examine that development and how different the development in Australia has been to other countries in order to understand where we've come from and the context in which occupational therapy began in our country. One of the points made by Professor Cusick and also in the earlier 1988 book of for the bicentenary of Australia, which was devised by the Occupational Therapy Association at that time and written by Barbara Anderson and Janet Ball, one of the important points that is made is the difference between the way occupational therapy began historically in Britain and in the United States on the one hand, and the way it began in Australia. In Britain, and more especially in the United States of America, occupational therapy was very deeply embedded in the initiatives of spiritual or faith organizations, and in particular the Quakers. For the Quakers in Boston in the United States were really the progenitors of the establishment of a profession, an occupational group of occupational therapists. And in Australia, partly because of the origins of our colonial experience and the establishment of the convict settlements in most parts of Australia, except South Australia, who always tell us and make very clear that they did not have convicts in that colony during the 19th century, that in Australia, the development of occupational therapy was an adjunct to the semi-military prison environment, which was the early history of most of the parts of Australia during the convict period. And the connection with asylums, jails, nursing facilities and other facilities provided by the Crown and by the organizations of government, and especially military government, meant that occupational therapy in our country did not grow out of a spiritual background, but grew out of a humanitarian background, often pioneered by women, in order to soften the somewhat brutal and somewhat harsh system of government which the colonial convict origins in Australia often produced. The lunatic asylums that were a feature of the law relating to mental health in the 19th century, and indeed right up to my time when I was studying law at the Sydney Law School in the 1960s, that system produced the lunatic asylums, and I had to study, in fact, when I was a young law clerk, the subject of lunacy. And lunacy was regulated by laws which were basically designed to ensure that there was no misuse of the power of detention any more in prisons than in lunatic asylums. That all began to change in the 1960s as we moved from lunacy to mental health and to different forms of regulation. And those changes produced changes, amongst other things, in the areas of occupational therapy. So these were the features of the early part of Australia's story. And Professor Cusick has made a point rising out of a study which is currently underway at the University of Sydney and doubtless elsewhere, where occupational therapy is examined at a tertiary level in Australia, that there needs to be a much closer dialogue with the First Nations people and an involvement of the First Nations people in the issues of occupational therapy special to their communities. In the past, all too often, the First Nations people were ignored in our policy. They were essentially an invisible people. Under our Australian Constitution of 1901, the Indigenous people were not even counted in the census, and they were excluded from the census and so were essentially non-persons. That was changed in the referendum of 1967, but it took an awful long time for us to get around even to that small change, protective of the dignity and rights of the Indigenous people. So consultation with First Nations people is a point that Professor Cusick makes as a high agenda item of occupational therapy, just as it is a high agenda item for the law and for politics, for governance, for our democracy, and for so many other areas in Australia's national life today. And so the lesson that I derive from my acquaintance with the history of occupational therapy is that much more needs to be done to review the story of how occupational therapy grew up in the life of Australia and how it developed in different environments of colonial, federal and subsequent periods in Australia, and how that came about, who were involved, based upon empirical information, developed from archival information that is contained in the records of Australia. All of this is very important because we learn from experience in so many areas that context is vital to an understanding of where we are. And therefore, I would urge Occupational Therapy Australia and its members to pay more and closer attention to the history of this particular occupational group, because out of an understanding of that history and out of that history will arise an understanding of the defects, the blemishes, and the omissions of occupational therapy in the past, and how we can improve that situation in the future. Now, I now want to turn to what is the major theme of my remarks today, and these remarks grow in part from my experience as a judge and a justice of the highest court, but also in part from my experience as a member of a minority who have suffered disadvantage, the LGBTIQ queer majority, those who have been stigmatized in the past and still to some extent today by reason of their sexual orientation or gender identity and experience. So I want to start with telling you about universal human rights and how I, as a little schoolboy, came first to know about universal human rights. And it happened in a very particular way. It happened, in fact, in 1949, when I was a schoolboy at a public school, Summerhill OC class in New South Wales, and I was in class 5A. And in that class, our teacher, Mr. Gorringe, came to the class very early in the year, and he gave us all a little document. And the document was printed on airmail paper, which I'd never seen before in 1948. And it was emblazoned with the banner of the United Nations, then a new organization which had been established to create a new world legal order after the terrible sufferings of the Second World War. And this document was the Universal Declaration of Human Rights. Mr. Gorringe told us of how after the war and after the end of the war in the detonation of the 2 atomic bombs over Hiroshima and Nagasaki in Japan that finished the war, came the understanding that unless we could do better as an international community, as nation states, and as subnational areas within nation states, to respect universal human rights in every walk of life and in every activity of human beings, then we would just go continuing the destruction of each other in terrible wars, and that would be very bad, especially since the development of the nuclear weapons. And this led to the Universal Declaration of Human Rights, which was drawn up by a committee that was headed by Eleanor Roosevelt. Now, I remembered Eleanor Roosevelt because she came to Australia in 1944 when I had just begun a kindergarten class. And we were lined up on the Concord Road in Sydney to watch a cavalcade go by with this great lady, Eleanor Roosevelt. And I swear that our eyes locked as she went by, and she was the person who was the chair of the committee that drafted the Universal Declaration of Human Rights. And that document expressed many fundamental rights which remain on the agenda of the international community, but they remain especially on the agenda of Australia, because although most nation states have adopted their own Bill of Rights with their own statements, which are usually moulded and adapted from the Universal Declaration, we in Australia knew better, and we never developed a national Bill of Rights. And we still resist even an act of the federal parliament stating all the fundamental rights which we accept in Australia as applicable to each and every one of us. However, although Australia stood aside to some extent from the international developments, those international developments went on. And in the Universal Declaration of Human Rights, there is expressed in Article 1 the great principle of the Universal Declaration of Human Rights, and it applies to law, to government, to occupational therapy and everything else. All persons are born free and equal in dignity and rights. All persons are born free and equal in dignity and rights. And then the rest of the provisions of the Universal Declaration set out what are the main rules of dignity and rights that are part of the Universal Declaration. Amongst those statements of universal rights are those in Article 23 of the UDHR. Article 23 contains the provision for the right to work. And there's the occupational side of occupational therapy. But then in Article 25, there is the right to health. And Article 25 expresses the right to health not in absolute terms, but in terms that can be understood. Everyone has the right to a standard of living adequate for the health and well-being of himself and his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, and other lack of livelihood in circumstances beyond their control. So they are the principles which was adopted in the Universal Declaration of Human Rights. And this ringing notion of a right to health has come down to us in many international conventions which go beyond a declaration and incorporate the Universal Declaration of a right to health in various terms in treaty obligations which Australia has accepted by joining the treaties where these statements exist. In the International Covenant on Economic and Social Rights of 1966, Article 12.1 includes the right to enjoy the highest attainable standard of physical and mental health, the highest attainable standard of physical and mental health. And later in 2006, in the Convention on the Rights of Persons with Disability, there are a number of provisions in that convention which Australia joined and ratified, which provide the context and the principles against which occupational health and occupational therapy has to be judged in Australia. In Article 25 of the Convention on the Rights of Persons with Disabilities is the statement that persons with disabilities enjoy the right to the highest attainable standards of health without discrimination on the basis of their disability. So there is a very important universal principle in the law of the United Nations and in the treaty law, which is binding on the nation states that subscribe to it, as Australia has. And Article 26 contains the provision for habilitation and rehabilitation. States parties must take effective and appropriate measures to organise, strengthen, extend habitation and rehabilitation. And states parties must recognise the right to social protection for these fundamental entitlements. In addition to these statements in great treaties of the United Nations, other statements containing fundamental principles have been adopted by near unanimous resolutions of the General Assembly of the United Nations. Thus, the Sustainable Development Goals were adopted by the General Assembly in 2015, setting forth what's called the 2030 agenda. That is the agenda that the United Nations and all its members have committed themselves to attaining before 2030. And so that agenda is a very important commitment, and Australia has been a party to that agenda. Sustainable Development Goal number 3 is an extremely important member of the Sustainable Development Goals, and it commits the international community and its members to providing good health and well-being for all people in the country, and to achieving universal health care that will be available to make sure that these are not just words on paper, but that these are converted in national policy, in budgetary allocations, and in the commitment of the nation states to providing universal health care and for people with ability and with disability. And it's in that context that we have to understand the National Disability Insurance Scheme, which was adopted in legislation in Australia in 2013 and was fully operational in our country in 2020. The National Disability Insurance Scheme is not strictly speaking an insurance scheme in the sense that you have to take out insurance in order to be covered. It's a statute of the Federal Parliament that is provided for all people in our nation, but it's one that springs from the sustainability notion and the commitment to efficiency, which is a feature of insurance. And in that sense, it is an insurance scheme. But in other senses, it is a scheme for universal rights and a scheme to ensure that the universal human right to healthcare is attained in our country. Now, many people in Australia say, what is the use of all of these grand statements? How do we pay any respect to these if they're not part of the law of the land? And that's not a bad question to ask in the context of Australia, which doesn't have its own national domestic Charter of Rights. And therefore, it's useful to us in Australia to respond to those who declare that you don't really need these statements, that we don't need a Bill of Rights for our country, and that the way in which we can deal with these matters in Australia is by enacting our own laws, such as the National Disability Insurance Scheme, and that's the way we do it. That's the way we do human rights. We do it by specific legislation. And that, it is said, is the democratic way. Now, the only problem with that theory of the law is that democracies tend to work pretty well in respect of the majority of people, or even a near majority of people, or a majority of the aggregate of people. But they're often not so effective in dealing with the problems of minorities, not so effective in dealing with Indigenous First Nations people, not so effective in dealing with LGBTIQ minorities, and sometimes less than fully effective in dealing with people with disabilities who are in need of occupational therapy and other support. And in answer to the suggestion that you don't really need national bills of rights because Parliament will fix things up, a very good instance of the answer to that contention is given by something that happened in South Africa in the year 2002 as a result of the application in a case in the Constitutional Court of South Africa of the South African Rainbow Constitution. This was the constitution that Nelson Mandela brought into effect when he became the president of the first all-nation voting democracy in South Africa. They introduced a Bill of Rights into their country, although it hadn't been a part of their tradition, just as in Australia it hasn't been a part of ours. But that constitution which they brought in contained a provision, section 6.1 of the South African Constitution, that states must respect, protect and promote the rights contained in the Bill of Rights in the South African Constitution. Section 8 of the South African Constitution said the Bill of Rights applies to all law and all branches of government, the legislature, the executive and the judiciary and all organs of the state. And then section 27 is one of the more specific provisions in South Africa. Everyone has the right to have access to healthcare services, including for reproductive health. And there is a provision the state must take reasonable legislative and other means within its available resources to achieve the progressive realization of these rights. So that was the background in which a case came to the Constitutional Court of South Africa in 2002 for the purpose of testing what the fundamental right to health in the South African Constitution provided. And it came about in a very interesting way. President Thabo Mbeki was the second president of South Africa. He succeeded Nelson Mandela when Mandela's term expired and he retired. And Thabo Mbeki, who had been an ANC activist during the period of apartheid, became and was elected the president. Thabo Mbeki was a very distinguished man, but examining the internet one night, he came along across a number of people who were asserting that HIV, which was then afflicting South Africa, so that South Africa had the highest levels of HIV in the whole world, that this was not caused by the HIV virus, but it was a disease of poverty, and you could use various means to overcome it. Some of them said you just had to eat more beetroot and rhubarb. Others said you just need to have a good shower, especially before or after sex. And these harebrained and crazy schemes got into the mind of the president of South Africa, Thabo Mbeki. And then in the situation of a huge epidemic of HIV and AIDS in South Africa, a number of human rights activists thought we must apply to the courts for the implementation of the fundamental right to health, which is provided in section 27 of our new constitution. And so the case went to the lower court, which upheld the claim, and it was made in the specific area of mother-to-child transmission, because a new drug had been developed in the United States in 1996-7 by the Boehringer Pharmaceutical Corporation for the purpose of preventing mother-to-child transmission. And that drug was called nevarapin. And the drug was extremely effective and extremely cheap. It cost less than $1 to give a mother expecting to give birth to a child nevarapin, and for $1 you could prevent the transmission of HIV from mother to child. And President Mbeki refused to support this, and he did not provide for nevarapin, and the result was that more than 300,000 babies were born to mothers with HIV who developed the symptoms of HIV and who in many cases went on subsequently, before the antiretroviral drugs were available, to die of AIDS. And so people took a case, human rights activists took a case to the Constitutional Court of South Africa, and they said it's true in Section 27, it has to be within the limited resources of the state. You can't ask for everything under the right to health. But where it's only $1 and where it's affecting the lives of hundreds of thousands of infants, this is a case where, with all the restraints that courts observe in relation to the executive government and the legislature, the court must step in. And the Constitutional Court of South Africa did step in, and it ordered the president to prepare an action plan that would ensure that all mothers in South Africa who were expecting to give birth to children would have access to nevirapine. And this is a very good answer, I think, when people in Australia, including very learned people, very experienced people, say, we don't need any of that in Australia. We're above all that. Parliament fixes everything up. Well, Parliament does mostly fix things up. But for the outlying cases, we need a fundamental Bill of Rights, and we need to have them in reserve and to be used in order to find the context of how we handle issues in occupational therapy and in other areas of activity, Aboriginal rights, gay rights, and other fields of endeavour, in order to make sure that the right thing is done and the fundamental human rights that had been promised in the Universal Declaration will, in the ultimate, be upheld by the law of the land. Now, in Australia, we don't have, as I've said, a fundamental Bill of Rights, but we do have other statutes and enactments of Parliament. We don't have a general right to health, in the sense that we don't have in most parts of Australia, and in the federal sphere, we don't have a general statement that there will be a fundamental right to health within all available resources to the extent that that is necessary. We don't have it, but we do have particular legislation which has been enacted. For example, the Mental Health Act of 2007 of New South Wales contained provisions for community treatment orders. And those community treatment orders could provide for orders to be made by magistrates, reviewable by a judge, that would order a person, say, with schizophrenic symptoms, and that would provide various orders that could be made. But one of the provisions in the New South Wales Act was that the order made should be the least restrictive community order that was applicable to the circumstances. In a case called S against the Southern Sydney and Illawarra Area Health Service, Mr. Justice Brereton in the Supreme Court of New South Wales had to deal with a case where a medical practitioner had, in the case of S, a schizophrenic, ordered that there be compulsory injections of risperdal Consta, a pharmaceutical used to control symptoms of schizophrenia. And the order was made by a magistrate. The patient, Mr. S, said, I have a history in the past of taking the oral dose. I don't want to have to go every fortnight and have an injection. I will take the oral dose. There was a genuine question as to whether he would conform to the oral dose. But when the matter came before Justice Brereton, he pulled back from saying that he has to have the injection, and in accordance with the provision in the law of the least restrictive community order, he said that at least in the first instance, the order that should be made, substituting for the magistrate's order, was that there should be an order that he has to take the oral infusion of the drug, and that has to be monitored to see whether that operates. This is the way human rights litigation and decision making is determined. You balance the different objectives of the legislation, and ultimately you have provisions for appeals, you have provisions of the principles that are applicable. These things are examined by independent decision makers, and those decisions are available to guide others in the way they deal with analogous cases. So this is how we have to do it in Australia. Now, of course, if every case were the subject of appeals, that would be extremely expensive. If every case were the subject of a lot of submissions and lawyers getting involved and others, that would be even more expensive. But ensuring that there is a balance of human rights is an important feature of a civilized society. Of course, I'm aware of the debates that have arisen in the area of occupational therapy concerning the NDIS controversy about independent assessment. And it is true that governments everywhere, not just in South Africa, but in Australia and other countries, will always try in their budgetary decisions to ensure that excessive expenditure is not spent on the provision of methods of examining the system of decision making and providing procedures for such examination that are disproportionately expensive. But independence, provisions for review, provisions ultimately to have matters reviewed by judges as wise as Justice Brereton, are very important in a rule of law and democratic human rights complying country. And that's why such things are an important feature of countries like our own. The challenges that are facing occupational therapy in Australia include the training of NDIS delegates, the training of therapists themselves to deal with the National Discrimination Insurance Scheme, the provision of more consultation with the First Nations people, both with occupational therapists who are themselves from the First Nations people, and also servicing the needs for occupational therapy amongst First Nation people. Often this is an area that is neglected, and it has to be given new attention in our new dispensation in dealing with our First Nations people in Australia. A huge proportion of occupational therapists in Australia, about 90%, are women. And that may be because women are often more likely to take low-paying employment and employment which is part-time, and fitting their employment into other activities of their lives. But ensuring that the best and the brightest join in occupational therapy and give the best and the most affordable healthcare available and needed to people in need of occupational therapy service is extremely important. Attracting members to the association, attracting members to continuing education. Judges now have to undergo continuing legal education. Barristers and solicitors have to undergo continuing education, and occupational therapists also need to undergo continuing education, because by knowing the history and by knowing the development of Occupational Therapy Australia and the professional organisation, we can find new opportunities and new necessities that can be served in this country. Now, finally, I want to say something about the groups that have been neglected in the past. I think I've said enough already to indicate that our history in Australia of our dealing with the Indigenous people is not one of which we can generally be proud. I believe successive governments in this country have tried to respond more effectively to the needs of the Indigenous people. The statement from the heart, joined in Uluru by the leaders of the Aboriginal community, have asked for a voice into our federal parliament because they feel, being a small minority of 1 to 2%, they've been overlooked and neglected, and the only area in which they've had a very large representation has been in prisons, where they have the biggest proportion of imprisonment of any racial group in the whole world, Aboriginals in our prisons in Australia. And so a voice is what they ask for. It's in a sense a statement in poetry, not prose, but we have to find a way in Australia to provide a voice and to listen to the Indigenous people, listen sincerely and without the disdain that existed in the past, and to find ways to respond, including in areas relevant to occupational therapy. Finally, in respect of LGBTIQ in Australia, queer Australians, as I'm learning to call it, this minority, I know, is also rather small, but it in the past has suffered very greatly from criminal laws and other sanctions that have been imposed upon gay people. I learned recently of the impact, especially in regional and rural Australia, of the isolation and discrimination and the social attitudes which are so hostile to gay people, of people who have been members of communities who are cast out in a cruel and unkind way, of the objections of many, especially of religious peoples, astonishingly, to sustaining the love and relationships of people. And my own life has taught me how important it is for people in my position to bring it home loud and clear to any audience the importance of providing for the fundamental human rights and equality of people in our country. And that includes for the First Nations people, for people with disabilities, mental and physical, and for people who are LGBTIQ. Now, being LGBTIQ is not a disability. It is not an illness. It is not a mental illness. The United Nations has, in clear decisions of the World Health Organization, made that absolutely clear. But it still is certainly a disadvantage in many walks of life in Australia. And it's very important for Australians, including occupational therapists in Australia, to be open-minded and to be alert to the possibility that the client before them may be somebody who is suffering particular disadvantages by reason of their sexual orientation or gender identity and expression, to be alert to that possibility, to be sensitive to that possibility, to be respectful of those who come with that possibility, and to be supportive of them as fellow human beings. And this is the essential principle of the Universal Declaration of Human Rights. All persons are born free and equal in dignity and rights. All persons are born free and equal in dignity and rights. And that should be the core principle of our Constitution, of our law, of our policies, of our enactments, but it isn't always so. And it should be a fundamental principle of occupational therapy and of the healthcare professions generally in seeking to help and support those who come into their care. and I therefore pay my respects, as I began, to the Indigenous people across our broad continental country. I pay my respects to people who are living with disabilities, and I remind us all of the International Convention that protects their rights and of our duties as a nation and as professionals to ensure that that is converted from words on paper into action in truth. And finally, for my own particular minority group, most of us are members of some minority or another, the LGBTIQ, queer Australians, I say to occupational therapists, be alert, the next person you meet may be a queer Australian. And if that is so, they may already be suffering discrimination and injustice. And part of the solution may be to reach out, to provide help, and to provide love and kindness, which is the ultimate motivating power of occupational therapy in Australia and the world.